Now let us discuss about the constitutional and legal provision for women in India. So regarding the constitutional provision, let us discuss about the fundamental rights. So the first one is Article 14. Article 14 എന്ന് പറഞ്ഞാൽ equality before law. The state shall not deny to any person equality before the law or the equal protection of the law within the territory of India. Next is Article 15. Article 15 പറയുന്നത് prohibition of discrimination on ground of religion, race, caste, sex or place of birth. The state shall not discriminate against any citizen on grounds only of religion, race, caste, sex or place of birth or any of them. Next is Article 16, that is equality of opportunity in matter of public employment. There shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state. No citizens shall on ground only of religion, race, caste, sex, place of birth, residence or any of them be ineligible for or discriminated against in respect of any employment or office under the state. So there should not be any discrimination against any people relating to religion, caste or place of birth for any employment in the state. അതാണ് അടുത്തത് ആർട്ടിക്കിൾ 39, that's relating to directive principle. ആർട്ടിക്കിൾ 39 പറയുന്നത് the state to direct its policy towards securing for men and women equally the right to an adequate means of livelihood. Article 39D states that equal pay for equal work for both men and women. Article 39A to promote justice on the basis of equal opportunity and to provide free legal aid by suitable legislation and to ensure that opportunity for securing justice are not denied to any citizen by reason of economic or other disability. So equal opportunity should be given to all and or to provide free legal aid for aid by suitable legislation. Why? For to ensure opportunity for securing justice should not be denied to any citizen regarding economic or other disability. ഏതെങ്കിലും എക്കണോമിക് അല്ലെങ്കിൽ അതർ ഡിസബിലിറ്റി കൊണ്ട് ഒരു മനുഷ്യനും ഒരു ലീഗൽ എയ്ഡ് അല്ലെങ്കിൽ ജസ്റ്റിസ് ഡിനൈ ചെയ്യാൻ പാടില്ല. അതിന് വേണ്ടിയിട്ടുള്ള കാര്യങ്ങൾ ചെയ്യണമെന്നുള്ളതാണ് 39A പറയുന്നത്. So Article 42 states that the state to make provision for securing just and humane condition of work and for maternity relief. So Article 46 states that the state to promote with special care educational and economic interest of the weaker section of the people and to protect them from injustice and all forms of exploitation. Next is Article 47. Article 47 states that the state to raise the level of nutrition and the standard of living of its people and the improvement of public health. Next is fundamental duty. That is Article 51AE of the Constitution says that it should promote harmony and spirit of common brotherhood among all the people of India and to renounce practice derogatory to the dignity of women. മനസ്സിലായോ? അപ്പം 51AE പറയുന്നത് the state should promote what? Peaceful, harmony and spirit of common brotherhood among all the people of India and should renounce what practices derogatory to the dignity of women. Next is regarding the reservation of seats. That is Article 243D3. 243D3 it states that not less than 1/3 of the total number of seats to be filled by direct election in every panchayat to be reserved for women and such seat to be allotted by rotation to different constituencies in a panchayat. Article 243D4 states not less than 1/3 of the total number of offices of the chairperson. Here it is chairperson in the panchayat at all level to be reserved for women. Article 243T3, it means not less than 1/3 of the total number of seats to be filled by direct election in every municipality. Here it is municipality. 243D is regarding the panchayat. Here it is 243T3 states direct election in every municipality to be reserved for women and such seat to be allotted by rotation to different constituencies in municipality. Article 243T4, it means that reservation of offices of chairperson in municipality for the SC and the ST and women in such a manner as the legislature of a state by law provide. So these are some of the constitutional provisions. Next, let us discuss about the legal provision. About legal provisions പറയുമ്പം these are some of the crimes under the Indian Penal Code. That is, first one is rape. The second one is kidnapping and abduction for different purpose, homicide for dowry, death and their attempts, torture, both mental and physical, molestation, sexual harassment. These are all crimes under Indian Penal Code. So rape is section 376 IPC. Kidnapping and abduction for different purpose, section 363, 373. Homicide for dowry, death and their attempt, section 302 bar 304 BIPC. Torture, both mental and physical, section 498A IPC. Molestation, section 354 IPC. Sexual harassment, section 509 IPC. So these are some of the legal provisions. Next is the special laws. That is, the first one is Factory Act, that is 1948. That is, a woman cannot be forced to work above 8 hours and ban employment of women except between 6 a.m. to 7 p.m. Okay, the next one is the Dowry Prohibition Act 1961. But dowry prohibition എന്ന് പറയുമ്പോൾ നിങ്ങൾക്ക് അറിയാം, prohibit the request, payment or acceptance of a dowry as consideration for the marriage where dowry is defined as a gift demanded or given as a precondition for a marriage. Okay, then Equal Remuneration Act 1976, which means provide equal pay for equal work for both men and women. Next is the Immoral Traffic Separation Act SITA 1956. This means the primary law dealing with the status of sex workers. According to this law, prostitutes can practice their trade privately but cannot legally solicit customers in public. I think you understood that. They can practice their trade privately, but they cannot legally solicit customers in public. Next is the Domestic Violence Act 2005. It is enacted to protect women from domestic violence. Okay, so here to provide protection to wife or female live-in partner. നമുക്കറിയാം ഇന്നിപ്പം എങ്ങനെയാണ് ലിവിങ് ടുഗെദർ എന്ന് നമ്മൾ പറയും. അപ്പോൾ അങ്ങനെ താമസിക്കുന്ന സ്ത്രീ അല്ലെങ്കിൽ വൈഫ്, അപ്പോൾ അവർക്ക് എങ്ങനെ പ്രൊട്ടക്ഷൻ കൊടുക്കാം? ടു പ്രൊവൈഡ് പ്രൊട്ടക്ഷൻ ടു ദ വൈഫ് ഓർ ഫീമെയിൽ ലിവിൻ പാർട്ട്ണർ. അത് ലിവിങ് ടുഗെദർ തന്നെയല്ല, ആ വീട്ടിലുള്ള സിസ്റ്റർ ആണെങ്കിലും മദർ ആണെങ്കിലും ഒക്കെ അതിനകത്ത് ആ പരിധിയിൽ വരുന്നതാണ്. ഫ്രം ഡൊമസ്റ്റിക് വയലൻസ് അറ്റ് ദ ഹാൻഡ് ഓഫ് ദ ഹസ്ബൻഡ് ഓർ മെയിൽ ലിവ്-ഇൻ പാർട്ട്ണർ ഓർ എസ് റിലേറ്റീവ്സ്. ദ ലോ ഓൾസോ എക്സ്റ്റെൻഡ് ഇറ്റ്സ് പ്രൊട്ടക്ഷൻ ടു വിമൻ ലിവിങ് in a household such as sisters, widows or mothers. Okay, the act include actual abuse or the threat of abuse, whether physical, sexual, verbal, emotional or economic. Harassment by way of unlawful dowry demands to the woman or her relative. So these all comes under Domestic Violence Act 2005. Next is the Sexual Harassment of Women at Workplace Prevention, Prohibition and Redressal Act 2013. It is to protect women from sexual harassment at their place of work, ensure that women are protected against sexual harassment at all the workplace, be it in public or in private. The next is the Family Court Act 1984, to establish court to settle matters relating to family law like matrimonial relief, custody of children, maintenance for wife and children. The next is the Special Marriage Act 1954, enacted to provide a special form of marriage for the people of India and all Indian nationals in foreign countries, irrespective of their religion or faith followed by either party. Next aspect is the Marriage Law Amendment Bill 2010. So, Hindu Marriage Act was amended to amend the Hindu Marriage Act 1955 and the Special Marriage Act 1954 to making divorce easier on the ground of irretrievable breakdown of marriage. ഓക്കെ സോ മാരേജ് ഇറിട്രിവബിൾ ആണെങ്കിൽ അത് പെട്ടെന്ന് ഡൈവേഴ്സ് ഈസി ആക്കാൻ വേണ്ടിയിട്ട് ഈ ഒരു മാരേജ് ലോ അമെൻമെൻറ്റ് ബില്ല് പാർലമെൻറ്റിൽ ഒരു പുട്ട് ഫോർവേഡ് ചെയ്തു ആൻഡ് വാസ് ഇൻട്രൊഡ്യൂസ്ഡ് ഇൻ ദ പാർലമെൻറ്റ് ഇൻ 2012. Next is the Maternity Benefit Act 1961. That is, every woman entitled to maternity benefit under this act shall also be entitled to receive from her employer a medical bonus if no prenatal confinement and postnatal care is provided for by the employer free of charge. The next is Medical Termination of Pregnancy MTP Act 1971, that is enacted with the intention of reducing the incidence of illegal abortion and consequent maternal mortality and morbidity. Okay, that is Medical Termination of Pregnancy Act 1971. Okay, so these are some of the legal provisions and special laws which are helpful for women. These are some of the laws. Next is regarding the contemporary policy initiatives, commission, committees, schemes, programs and plan for women in India. So the first one is Beti Bachao, Beti Padhao. It was launched in January 22nd, 2015 by PM Narendra Modi, our Prime Minister Narendra Modi. And this is a joint initiative of the Ministry of Women and Child Development, Ministry of Health and Family Welfare, Ministry of Human Resource Development. So its aim was actually to address the issues of declining child sex ratio, and the objectives of this are prevention of gender biased sex selective elimination, ensuring survival and protection of the girl child, ensuring education and participation of the girl child. Next is the National Policy for the Empowerment of Women 2001. The Department of Women and Child Development in the Ministry of Human Resource Development has prepared a national policy for the empowerment of women in the year 2001. And the objective of this policy is for creating an environment through positive economic and social policies for fulfilling development of women to enable them to realize their full potential. Fundamental freedom for women on equal basis with men in all spheres. Okay, so equal access to participation and decision making of women in social, political and economic life of the nation. Equal access to women to health care, quality education at all levels, career and vocational guidance, employment, equal remuneration, occupational health and safety, social security and public office. Strengthening legal system aimed at elimination of all forms of discrimination against women. Changing societal attitude and community practice by active participation and involvement of both men and women. Mainstreaming a gender perspective in the development process, elimination of discrimination and all forms of violence against women and girl child. Next is the National Mission for Empowerment of Women, NMEW. So, ഇതിൻ്റെ എക്സ്പാൻഷൻ ചോദിച്ചാൽ National Mission for Empowerment of Women, NMEW. It was launched by the Government of India on an International Women's Day in 2010. So, the aim was to strengthen, promote an all-round development of women. The focus area of the mission was violence against women, declining child sex ratio, prevention of child marriage, trafficking, health and sanitation, drinking water, right to education, etc. This was the focus area. How to handle these things. These were the focus area. Next is the National Commission for Women. So it was set up as a statutory body in January 1992 under the National Commission for Women Act 1990. So to review the constitutional and legal safeguard for women, recommend remedial legislative relief measures, then facilitate redressal of grievance and advise the women on all policy matters affecting women, initiated various steps to improve the status of women and work for the economic empowerment, organizes workshop consultations, constitute expert committee on the economic empowerment of women, conduct seminars, workshops for gender awareness, violence against women, etc. So these are some of the the initiatives taken by some of the policies taken by the government of India for helping the women. Okay, thank you.